I'm Roger Citron, and I'm a professor at Toro College, Jacob D. Fuchsberg Law Center. This is a Toro Law Review podcast, and our guest tonight, it's 7 p.m. as I'm talking to our guest today, is Robin Peguero. He is a lawyer, he is a published author, and tonight we're going to talk about both of those things in light of the publication of his first novel, which this is the dramatic reveal. I don't know how well you can see it, but this is his novel in hardback. It is called With Prejudice, and it was published this year. And so let me start by asking you, Robin, just tell us a little bit about yourself.
Will do. Thank you so much for having me. So I grew up in Miami, Florida. I'm the son of two immigrant parents. My mom emigrated here from Ecuador, my dad from the Dominican Republic. I went off to college at Harvard, then did 4 years working in Congress on Capitol Hill as a press spokesman for a member of the House, and then a speechwriter for a member of the Senate. Went back up to Harvard for law school. And after I finished at law school, I began my legal career as a homicide prosecutor. Well, as a prosecutor, made my way up to becoming a homicide prosecutor by the time my time was done there 7 years later. Currently, I am investigative counsel for the January 6th Select Committee. Moved up to DC back in October of last year to do that. And as you mentioned, I also, thankfully, very fortunately, had my first novel published in May of this past year, 2021. So excited to be here with you and answer all your questions.
Yeah, I'm going to say to you the highest compliment that I give the students at graduation, which is you've been busy. And I read your novel. I'll tell you why I read it. There was, I believe it was blurred by, among others, Scott Turow, and I'm a huge fan. And so that led me to the novel. I read it earlier this summer. I enjoyed it. And we'll try not to spoil too much for those who haven't read the novel yet. Let me ask, when did you decide to write a novel?
Well, I've been writing since I was a little kid. I have a distinct memory of on the playground while other children were playing. I was off in a corner in my notebook, just spinning tales, writing fiction and writing, long form fiction. I put out this weekly chapters that I would give my friends in high school with us as the characters. I wrote several books in that fashion. So I've been writing since I was little, but when I decided to be serious about it, was actually I wrote first for publication, or for an attempt to publish to get it public, was a book about my mother, and it was sort of a magical realist literary fiction take on her life. And it was actually that I had sent to my now agent. That was the first thing that sort of piqued his interest, and we had a phone call. And by the end of the phone call, I happened to just mention, I'm also a prosecutor, and I decided while I was, putting this out, I would write something else. I'd write something that I think would be a little bit more commercial, something that was, a thriller set in the courtroom. And mostly because I had been dealing with such dramatic, sometimes tragic, but certainly very intriguing matter for the past 7 years. And I thought to myself, this is a good setting for both something that would be entertaining, but then I also think something that could speak to society, reveal something that isn't particularly well known, and hopefully get people thinking about the criminal justice system from a perspective that isn't always told. People from different races, backgrounds, thoughts that I kind of wanted to integrate that I didn't normally see in legal thrillers. And so it was at that juncture when he heard that he said, hey, let me read that. And when he read it, he said, this is the first one we got to go out with. It's timely, and I think would catch a lot of attention. And so I've always been thinking about writing novels, but it wasn't really till 2017 when I started to send out work with the hopes of getting published.
There's a lot in what you just said. Let me try and pick up one or two threads. Before you wrote this book, the thriller With Prejudice, the legal thriller, Uh, did you read many others? And I asked because I you know, in talking to another author about sort of like a similar type of question, he said, "Oh, absolutely not, because I'm afraid that would seep into my mind, and then inadvertently, I might wind up sort of saying something similar. In other words, I don't want to risk the influence." On the other hand, this is a familiar genre, and I wonder whether how much you may have immersed yourself in it, just either generally or just to write the novel, or specifically to write the novel.
Yeah, no, it certainly wasn't intentional. Either the fact that I actually don't have too much experience in legal thrillers, but nor that I had just growing up some exposure to it. So really through other forms of multimedia, my mom is a fan of John Grisham, and so we watched a lot of the movies that were made off of his books, like A Time to Kill, Runaway Jury, stuff like that. So I had exposure to the genre, but through the visual medium. And I did read Presumed Innocent by Scott Turow, so I've had that sort of in the back of my mind. But certainly when I was putting it together, I didn't either pick up a legal thriller or have it refresh my thought process in any way. But again, it wasn't intentional. I wasn't worried that it would sort of affect what I would do, because I do think that although it is a legal thriller, it's very different as well. I think there are elements of literary fiction. I think it is sort of character driven and not entirely plot driven. And hopefully there's a little bit of balance to both. And I think I wanted to make sure that the ending was building towards something, that it was exciting, that there was a payoff like you get in a thriller. But I also wanted there to be value in the journey in getting there. And so I think it's somewhat of an unconventional legal thriller. But I'm certainly grateful and thankful to the, sort of giants of the genre from before, particularly obviously Scott Turow, who wrote such a nice sort of blurb about my book. So I'm very appreciative of that.
Yeah, I have to just ask one more, before we. So the novel, that is about your mother, if that's a fair characterization. Um, will that be coming out anytime soon, or you're reworking, or where is that?
Yeah, I'm working next on a political thriller, so I'm trying to stay within the field with my current publisher. But I've got another sort of sci-fi book also that I've written. There's a lot of other projects that are sort of kind of up on the shelf that I hope to dust off and sort of put out there later in time. But I'm trying to just sort of get my name established in this field first, and so the political thriller is what's coming up next.
Okay. Um, I, you know, a slight confessional. When I think about reading, of course, I think about my mother as well. And so, um, whenever it comes out, I, I know I'll read
Oh,
the first one
thank
that
you.
you mentioned.
Appreciate
Um,
it.
yeah. And then I kind of want to ask this question broadly because we've talked about it, but in writing with Prejudice, how did your legal training and experience inform you know how you wrote the novel? And I, I I don't know if we've plumbed that entirely, but I just want to ask it to see if there's anything that we've left out in that discussion so far.
Sure. So certainly, I wanted to make sure that it was accurate. Sometimes, especially lawyers, you can watch shows or read books in which a lot of the legal part of it sort of falls apart and doesn't ring true and isn't realistic. Now, on the other side of it, you don't want to get too far off into legalese so that it either becomes tiresome or completely confusing for someone without a law degree. So I was hoping to kind of strike a balance, right? So that lawyers could recognize the rules, could recognize reality in what they're seeing. You also, want to throw in some drama, and so that you work around sort of the edges of the rules. I think daily court is exciting and dramatic, but you want to ramp it up a little bit. It's not all happening in one trial normally, and thankfully you have that artistic license to do it. But I didn't want anyone coming away thinking there's no way, what is that person from the jury yelling and screaming in the middle of the trial, the surprise witness that hasn't been listed by anyone in discovery. Like, those things are not common or allowed. So definitely my experience colored the way I wrote it in that respect. It also, I think, is largely based on things that have happened to me or my colleagues. The story itself, the trial itself, isn't patterned after a case I had. It is completely fiction. But the little pieces, the sort of dilemmas that the lawyers undergo, the discussions they have, those all come from a real place. And even some stories, some of the small things, were things that happened to me or my friends. And so it definitely is reflective of my experience. I hope that people come away thinking, okay, a homicide prosecutor wrote this, because that was my intent.
Mhm. One of the things that I really enjoyed about it, because I practiced for a number of years, including for the government before becoming a professor, um, you really do a nice job depicting the culture or subculture, for example, like of the prosecution, of the defense. And then I also thought, there's a piece in there about not just the responsibilities of being a judge, but how you become a judge, or how, someone who wants to do that, what you might have to think about along those lines. And I take it that, from the way you're talking, that is, you would say, oh, this is, I'm not claiming it's a documentary, but this is a pretty accurate or facsimile or depiction or representation, of what these worlds are like, and then what happens when you put them all together in a trial in a courtroom.
Yes, certainly.
Yeah,
I think these are human beings. They have different interests, different perspectives, different things that are motivating them. And so you mentioned the judge, right? And in the state of Florida, judges are elected. And so that is a component. That is something they have to think about. And of course, they have an oath. They take an oath to make sure that they're defending both the constitutions of the United States and that of Florida, and that they're applying the law dispassionately, as objectively as possible. But they're human beings, and they have motivations, and they are thinking about that next election, because we are survivalists at nature as people. And so I I didn't want it to be overly cynical, but I did want to sort of unveil those considerations, those machinations, and have it be sort of a single thread throughout everyone. So that's the judge, right? The one of the most powerful people in the courtroom, but all the way down to the jurors, who I actually think are the most powerful characters in the courtroom, but they're not thinking about an election, right? They don't have those considerations. They're supposed to just be everyday, average, ordinary Americans using their experiences to come up with an objective verdict. But even they have political motivations. They have perspectives. They have biases that either subconsciously or intentionally are coloring the way that they view things. And so I kind of wanted, as disparate positioning as from the judge to the jury to the different um, lawyers and the players, the witnesses at heart, all of them are still plagued with the same human flaws that ultimately shape how we get what we call justice in the end.
yeah, yeah, and that's actually, especially the jurors, I thought was a really interesting piece. So I have to ask, 12 Angry Men, have you ever read it, seen it? If so, which one? Was that on your, in any way, part of your thinking, in constructing this jury for your novel, the jury for your novel?
Absolutely. I grew up on it. I watched it really, really early on. The movie, the black and white movie with Fonda, I believe, is the actor, if
Yes,
I'm not
Henry
mistaken.
Fonda. Yes,
Yep.
among others. There's many others
Right.
you're
Of course.
familiar, but yes, he's the star.
And I've heard the audio book, like of the play, before. I've seen it in different forms. Um, and I think I've read also the screenplay. No, it was remarkable to me. And so I've always kind of had a little bit of a soft spot for the jury. While in law school, even before I practiced, that just I my note in law on law review dealt with jury nullification. I always found it completely fascinating that we have this social experiment of jurors getting together, people who have never met, who at that point hadn't talked about anything substantively if they've been following the judge's directions, just about, their days and high and by. So they have no idea really how they argue, what style, even how their voice sounds, their inflections when they're angry or when they're argumentative. And to have them come to one decision, I've always thought that that was remarkably fascinating. And so 12 Angry Men certainly sort of played into how I saw it, and more than the actual deliberations, which I think are interesting, are fascinating. They're a black box. We don't get to see them. We don't get to review them. They're not taped. So certainly there is value in hearing about it. But more so for me, again, it was the thought of what in their pasts inform the way that they're going to argue and debate once they're in that room. Because I think that that's the part that I think isn't intuitive to people. Certainly, they have discussions over the dinner table, even about politics, about religion, with their family, with friends, that they're used to maybe that sort of contention, but they're not used to how their thoughts and their experiences and those biases would play out in a system that is supposed to be completely, you're not supposed to use any of those influences. They're supposed to be left at the door, right? But I kind of want to lift the veil on that idea.
Yeah, and I want to stay with the jury piece because, of course, I teach civil procedure, and so midway through the second semester in civil procedure 2, we get to the Seventh Amendment, right, for civil juries. Can I ask first? Let's say in your time as a homicide, just when you were doing the homicide prosecutions, how many cases did you try to, that actually went to verdict to a jury? Just to get a sense of your experience, just to get a sense of your
Sure.
experience.
I know I did 30 jury trials to verdict, period, over the course of my time. I think only 6 or 7 of those were misdemeanors, so it should have been about 21 felony verdicts to trial. Homicide, I was a homicide prosecutor for 3 years, in part, unfortunately, during the pandemic. But so I've done 3, depending on your definition, because I have, I did a second-degree murder, another second-degree murder, but then also several DUI manslaughters and vehicular homicides. So probably the verdict, maybe 6 or 7.
Yeah, no, that's substantial experience for any law students who are listening, and anyone who's at a law firm will also tell you that's a lot of jury verdicts. So can I ask, do you believe in the jury system? That is, having toiled, right, having labored, and tried cases to a jury, the cases that you've accounted for us or recounted for us. Do you believe in the jury system?
So I can tell you that I'm far less partial to the adversarial system. I think, having undergone it, I don't know that 2 sides with opposing sort of motivations, that's going to come out to the actual truth. I mean, it certainly ends up in some sort of result, but not necessarily the truth. And the sort of inquisitorial systems in Europe sometimes are more geared toward the truth, although they give fewer rights to the defendant by design, right? Because if you're telling the defendant that, there's not the right to self-incriminate, then often we're not going to get at the truth. We're going to have protections for him, and then feel confident, I think, about the conviction at the end, because we've sort of given so many protections to the defendant beforehand. In terms of the jury system, I'm actually far more agnostic about it. I am really fascinated, again, by the idea of a jury of your peers. What I wanted to do with the book was less criticize it, less say that it isn't the best system that we can come up with, given that human players are going to have to ultimately play a role. It was to say it isn't what you think it is. It is not objective facts. There are lenses with which we see facts, right? There's the Rodney King beatings, as I mentioned in the book, videotaped, and yet one human being will see a completely different thing, a man resisting arrest, versus another who will see police brutality. And so I think that the notion that, you're getting an objective 6 in Florida, another place is 12, together in one room, and they're peeling away their biases, and that's what justice looks like, I think that that's not right. I think it is far more arbitrary than we give it credit, and that often the verdict is settled merely by jury picking. It's not sure, it's not certain that the lawyers know which way everyone will go, but that at that moment you've picked people who are predisposed to view facts in certain ways, and that can be arbitrary. That can lead to different outcomes depending on which jury is selected. And so I wanted that truism to be put out there. And ultimately, I do believe in the system. I would not have participated in it for so long if I didn't believe ultimately that this is a good justice system that tries its best. But I think it obviously needs reform, and I think on the margins it can be reformed so that it can be better.
Okay. And the reforms would be?
Oh, like I said, more toward the adversarial nature than I do think towards the jury aspect. I think that once at least we accept the fact that there is no such thing as an objective juror, we're getting closer in kind to what we need to be thinking about. And so there's this example, I quoted it I think in my article that I wrote about jury nullification, about, okay, there's a Catholic priest on trial, so you don't have, let's say you kick off people who are Catholic or who feel strongly about Catholicism. Well, then there are Protestants. There's always an opposing view that you're kicking off anybody, really, everybody with any sort of like one view, the opposite view. You end up maybe with people who are either completely uninterested in anything outside themselves, or not interested in the news, so completely oblivious to what's going on around them, haven't really thought about the issues before, death penalty cases, right? So you want someone who hasn't had fully formed opinions on it, which, why? They're human beings, intelligent human beings in this world. It's perfectly fine that they've come with opinions and thoughts on something as consequential as the death penalty or the criminal justice system writ large. And so I think once we put aside at least that sort of pretense that we can sort of carve out ultra objective juries, then I think we can think about what makes people tick and try not so much on the front end to control what they're going to do on the back end. So those are my thoughts on the jury, at least.
Yeah. And if I could just stay with it for one more,
Sure.
What do you think about deliberation in the jury context, especially because I did not know prior to reading the novel that you could actually, in a criminal case, that it was 6 in Florida. And I guess that just goes to my own ignorance. But I was, of course, thinking of, in federal, I believe, right? I believe it has to be 12. I think in New York it might have to be 12 too. I'm not 100% sure about that. I've actually served on criminal juries, both in state and federal court. But I did not know that you could go down to 6, or that 6 was standard in Florida. And to tie that back to the deliberation piece, even understanding, I mean, one of the wonderful things about the novel, the fact that it's set in Miami, which of course is such a diverse place, and you really bring together lots of different types of people on the jury, but throughout the novel, there are these interactions, and so I guess the question I'm getting towards is the idea that we come together and have our different perspectives as individuals, and yet we're supposed to sort of talk through the case, and then of course, as you say, the judge will instruct, even if you think you're deadlocked, you've got to at least keep trying to come to agreement. And so it's a deliberative process. And do you think that do you think deliberation is helpful, effective, sufficient, whichever one of those adjectives is worth responding to?
Sure. And I think that that's the idea, right? That through discussion, through the art of persuasion, people will move toward consensus, and maybe that consensus is the right answer. The issue with that, of course, is that for the same reasons that the number one reason that we say we give the defendant the right to remain silent. He or she, of course, may not be guilty, but may just have issues with public speaking, right? May not be able to advocate for themselves well up on the stand, and that has nothing to do with guilt or innocence. In that same way, for some odd reason, we rely on 6 in Florida, but it's 12 in capital cases, right? So if there's a death penalty that is available and hasn't been waived by the state of Florida, then yes, it needs to be 12. But otherwise, just 6 in Florida. And I even think there are some, I thought in some jurisdictions in Louisiana, potential misdemeanors, it doesn't even need to be unanimous. I think it could be a majority. So different across the country. It has to be unanimous in Florida, but only 6. But this idea that, 6 people, they need to have the sort of public speaking or persuasive skills to be able to be on equal footing. I recall a judge who would, every young person, she would always ask during voir dire, like, can you stand up for yourself? Like, how do you respond to older people? Do you feel as though, like, you can have your own voice in there, or will you just go along with what elders might say? And that is a perfectly normal consideration throughout age, just personality types. If someone says an untoward comment, you might not like that person anymore. And then now the things that they're saying, you might not only take with a grain of salt, you may actively want to argue against that position, even if it may be naturally what you either would have thought before you found out that this person who you dislike or don't trust very much had that same view. Maybe your racial politics. If someone of a certain race says something, might actually lead you to be more receptive to the idea or less. There's so attractiveness. They've done studies. The attractiveness of the attorneys sometimes will affect whose version of the truth you accept and who's more persuasive. And so this idea that it's deliberative, it's liberation, sure, but there's so many different arbitrary factors that are going into the mix that you're not quite sure where it's going to end up. And as I said, that's fascinating, and I think it's great drama for a book. But also in a system where you're trying to come up with the right answer, that can be, quite scary.
Yes. No, and I have to indulge one anecdote, because I was a law clerk for a trial court judge. We did the judge presided over a very long civil trial involving a suit against an insurance company. And it was a contentious case, and we kind of knew going into it, because of the many motions that had been filed and some of the hearings, that there was a lot at stake for the attorneys, and they weren't openly hostile, but there was real friction between them. And I'll try and get to the point. The case was tried. It went on for, I think, easily more than a month, and the jurors got to a verdict, and the judge, as was his practice, especially I think he was very grateful that the people on the case had put in literally a month of their time at least on the case, brought them back into chambers. And this was something that he did as a way of it was like the sort of thank you for your service speech. And he wouldn't he didn't want to talk about the case. He sort of felt like you rendered your verdict. But here, I think people were a little bit chatty. And the only thing that was, I think, the thing that I remember most was their perceptions of the attorneys were so different from ours. And part of it was that I think that on one side, it was the attorney sitting by himself. On the other side, it was an attorney and I think an assistant. But I think someone commented that I guess they'd seen them smirk to each other. And it really left a lasting influence, because it was one of those experiences of like, we were all in there too. And walking out, it was night, it was day. That was a perception of that. And it goes to this very human quality of, I think, what you're talking about, what you wrote about here. And it's really sort of a fascinating question about how much can we get beyond our sort of ourselves, right? Our our perceptions, our implicit biases, our explicit ones, in some cases, that kind of thing. So this really, I think that the book is very helpful, law students, law professors, to getting a sort of window into, this is a way to sort of at least raise questions about the jury process, and the jury system. Um, I'll I'll go to a question now, which is, you mentioned you're still practicing law, right? Or you're still you're a lawyer up on Capitol Hill now. And do you like being an attorney? And this is sort of for our, for students listening. Tell us about, tell me about what you think about being an attorney, and do you see yourself doing that for 3, 5, 10, the foreseeable future kind of thing?
Sure. I certainly maybe see myself as a writer first. I just always have, because it was my first passion, continues to be my first passion. And it was really on the Hill when I decided I would go to law school, so right out of college. So it hasn't been a lifelong dream of mine. I just realized that the change that the government can make, I think for good, often is slow coming. It's deliberative. It takes a while to see those results, and you're not getting that sort of day-to-day, one-to-one interaction with the people you're helping, the sort of fulfilling, rewarding feeling that I think I thought I would get as a lawyer, and that's why I went to law school. And I knew I would only do public interest, and was pretty geared towards criminal law. I was the president of my public defender organization in law school, and so I was actually kind of naturally inclined to do that. And I realized that too often we self-select, and there was a lot of power on the prosecutorial side in our system, and so it was maybe it behooved me to be there. I think I could, on the margins, make more change there, and I also felt it was important to have diversity in government. If we're going to be prosecuting people, the prosecutors and the ones making the decisions should often look like the people who are being ensnared in the system. And so I did that, and I do like being a lawyer. I do think that it gave me a sort of analytical skill set that has been helpful. I do think that the adversarial system can be very tiring. It can be very taxing. I did call prosecution a little bit of a thankless, I call it a joyless job sometimes. But that's because, you're moving from tragedy to tragedy, and sort of at any given moment, everybody in the courtroom can be upset with you at once. The judge has certain expectations. Defense attorneys, naturally, they're adversaries. You're of course trying to be collegial and professional. And I think I've been told that we're actually quite collegial criminal lawyers, far more than civil lawyers, where they're dealing with money. Who would have thought? They get far more aggressive and angry, but nonetheless, it's still adversarial. So you're arguing for a living. You're battling one another at the podium. The defendant certainly isn't happy with you, and often the defendant's family, and then sometimes even the victims, who aren't your clients, of course, but your interests align. They can expect a lot from a criminal justice system that just won't give them exactly the closure that they want. And often, of course, as is right with our system, there are people who are found not guilty. There are people who get lesser sentences than what the victims would have wanted. And so at any given moment, there are these people upset with you. It's a stressful, like I said, very taxing, emotionally taxing job. And so after 7 years, I felt like, okay, that was it for now. That was fine. But I absolutely did enjoy it nonetheless. It was extremely interesting, extremely rewarding, extremely fulfilling. And I know that there are pockets of the law that people go into purely based on finances, purely based on money, and they don't love it, right? They don't get that same sort of enjoyment that I did from my job because of how interesting and intriguing it is. And so I do love being a lawyer. I would just say make sure you're doing it for the right reasons. You're doing it because you love the work, and you find it interesting, and it captivates you, and you're pursuing hopefully good in this world, and not just for monetary reasons, if you can help it. Of course, everyone comes out of law school with different situations and have different family backgrounds, of course, that dictate where we can and can't go in terms of our career. But the job I have now, completely different. Weirdly, I always found on the Hill, you would figure to be adversarial, but it's not. because you're not so much dealing with the other side. You're mostly working within your sort of own office where everyone has generally the same views and generally the same goals. And so, it's a nice respite from that sort of adversarial side. But I do absolutely like being a lawyer. And, it's sort of a joke, I think, to law students. Lawyers tell them, hey, don't become a lawyer. I never do that. I think it's a worthwhile endeavor, and I'm happy and appreciate being part of a profession that does hold itself to certain standards and ethics, and it's nice.
Yes, yes. No, I especially, I mean, at some point in law school, the brass ring for me became the Department of Justice. And I never did criminal work, but I had some, two different civil jobs in Washington, one at the Department of Justice and one at the FCC. And so I really, you know, was probably, I was nodding physically, but certainly I was in my mind completely agreeing with what you were talking about in terms of the rewards of public service or public interest work. And can I ask about that? What you said about being a prosecutor, that is bringing, if I can say it this way, diversity to the office, that is into, that's the prosecutor has extraordinary power. Did you find that, you actually, in that piece, in that sense, made a difference? That is, did that turn out to be a satisfying or unsatisfying part of the experience, which was that, bringing diversity into the office, and if I can say it this way, being a person of color as a prosecutor. Just if you could say a little bit more about that, it's just really interesting to me.
Sure. No, I do think that I was worried that I would become a prosecutor and I'd be somewhat captured, I guess, by
Mhm.
the inertia of the place. Ultimately, you are sending people to jail. You're sending people to prison. That's generally the direction you're going. And you can do things on the margins, but that is your ultimately your goal on cases in which you think it obviously merits it, in which there is proof beyond a reasonable doubt, and the facts and or priors surrounding what the person has done uh, represents or deserves merits jail or prison. And so that can be difficult, I think, in a sense, because there are certain expectations put upon you by the other side. I think that I would act a certain way, and I do think I was able on the margins to be sympathetic to the certainly to defendants' rights, always extremely cognizant of not trampling on them and making sure that they were upheld. Um, on my end, I know very much that I was able to affect my colleagues, because I know from the beginning I brought up questions, even just sometimes the language we use, because people will use demeaning sometimes language about defendants, about people who perpetrate crimes. For me, I never saw it as uh, I didn't see it as a summing up their value as a human being. I saw it as a bad act that deserved punishment and sometimes deserved significant punishment. It doesn't necessarily mean that someone who murders someone doesn't deserve to be put into custody for a very long time, if not for life, depending on the severity of the action. But I didn't see the need to judge the person or call the person a certain thing outside of the act itself. And so I know in language I had some impact. I know in trying to come up with things that were not jail alternatives or trying to understand certain motivations. I know that I had those conversations on my end and that they were helpful, and I was able to persuade some of my colleagues to think about it in a new light. That said, I'm sure the other side, I would make my own determinations, like the pleas that I would offer based on factors that the other side already wanted me to take into account. And so I wasn't a very good negotiator because I didn't feel good about inflating numbers for the sake of it, just to arrive at a number
In the
to make
middle,
the
yes.
in the middle to make the lawyer happy. That's okay with money, but to me, that's not okay with people's lives, because I thought the lowest possible number of jail, let's say, days in custody that I thought comported with all the interests penological interests, that's the only responsible plea. It can't be a day over. Because if I'm willing to go a day under, then I should start off at a day under. So I think people thought I was just unreasonable because I always started at my absolute minimum. And my colleagues, again, who would inflate, add a bunch of years, add a bunch of, and then later come down to the exact same point, they were seen as far more empathetic. But I do think it can be difficult to sit across from someone who looks like you, maybe, who maybe had a similar upbringing, who maybe has the same last name, and have either them or their family feel as though you are either being a traitor or something like that. But to me, I actually got I felt a lot of pride in that because I didn't want the same excuses to be held out. Obviously, if I'm on trial, if I'm pursuing a case, I believe this person committed it beyond a reasonable doubt. I don't want that person to say the only reason I'm being prosecuted, the only reason I'm here is because of the color of my skin, or I'm being actively discriminated against. Because then I think the whole purpose, which is deterrence, is to keep them from doing it again and others from looking at that and doing it again, is completely defeated. And a lot of times in our system, we build up so much the defense that people do come away even after a full trial. They've heard all the evidence against them. They had a jury of their peers tell them, no, what you did was wrong. And yet there's still avenues for them to say, no, the prosecutor was biased, the judge was biased, this, that, and the other. And there's never a reckoning. There's never an actual moment where there's a lesson learned, which is really all I cared about. I didn't care about, prison, how long. What I wanted most is just the expressive function of a trial. What you did was wrong, to sink in, because I think that's the most beneficial, the whole point of the exercise. And so at least I hoped that they would maybe see someone who looked like them on the other side and think, okay, maybe I've done something wrong here, and maybe at least, even if obviously they can disagree with the verdict, it's their own lives and the lives of their family, I understand that, but maybe they won't so quickly just write off the whole trial, write off the criminal justice system as racist, which it can be, but not in every instance, of course.
It's been very interesting. I was actually, marking the time where we spoke about this, because I'm going to absolutely forward this to, the criminal law and criminal procedure professors, because I think that there's a lot of important things that you're addressing here, in terms of responsibilities, and as well as functions or purposes of the system. Can I ask, this is kind of a catch-all, because I think that from our conversation so far, I'd say there's sort of two threads. Which one is that you found the work very personally satisfying, very personally rewarding, and that as to the operation of the criminal justice system, which of course inevitably reflects society, there's it's not perfect. That is, that there certainly are shortcomings, and so the way I want to try and just sort of put it together as a question is, with what we've been talking about, informed by your personal experience, as an attorney and as a prosecutor, how did you think about putting that into the novel? And maybe you could sort of talk about some of the choices you made, as you were working through the story and with what we end up reading.
Yeah, well, a big motivation I had was to sort of flip on its head I think the traditional notion that kind of the defense attorney is sort of lionized and is a little bit of the hero, and usually the prosecutors, Kevin Spacey in A Time to Kill, kind of a jerk certainly, and has sort of maybe ill motives. I wanted it to, because I think it's more nuanced and I think it's more complicated. I also don't think that we should flip it in the defense attorney. There are some also media representations of defense attorneys as, not noble, as liars, as not good people, and I think that that's wrong. But I think it's completely nuanced, and I don't think it lines up as well with progressive and conservative as people make it out to be, as even certain progressive defense attorneys made it out to be. There was a sort of sense of righteousness of, well, What you're doing is putting someone in a cage, and there's some of that discussion in there, and the conflict I think that the lead prosecutor feels, that that's a genuine one that I felt. And I think, but I think there are things that defense attorneys do that progressive defense attorneys will find noxious, will be difficult, and that maybe they didn't realize. They often, their politics don't always align with lesser enforcement. Usually rape cases, which I think most progressives feel are under enforced or difficult to convince juries have actually happened. Crimes against certain vulnerable communities. Gun control legislation, gun crimes. Often these are times when actually progressives are more pro enforcement. Crimes when an officer commits them, certainly. And defense attorneys sometimes have to get up there and they have to do things that are sort of against their personal moral code. They have to, call out a sexual assault victim for what she was wearing. There was a case of a colleague of mine, thankfully I didn't have it, where she was prosecuting a man, the sexual assault, the rape of an 8-year-old, and the defense is, and it was successful. It was a not guilty, and the reason was in line with what the defense was, which was ultimately she instigated it, that she wanted it, in essence, which is not really a viable defense, obviously, given that you cannot consent at the age of 8. But again, juries will do what they will, even sometimes in contravention of the law and what was explained to them by the judge. So there are horrible things, I think, that defense attorneys will have to experience, all toward a noble goal, which is ultimately hold the state, the government, to its burden. And you can't choose your clients, especially public defenders. Obviously, I guess when you're a private attorney, you can. Everyone deserves that defense, because we never know which one of us might end up where, and who's guilty and who's innocent. And so I wanted it to be a conflict for everyone. I wanted both the reader to see what's difficult from a prosecutorial perspective, and also what's difficult from a defense perspective. That it's far more nuanced than just good versus evil. It really is these players being put into this moment, trying their best to do their jobs, and hopefully come away with the best possible result. And so a lot of that influenced my writing. A lot of, obviously, it was important to talk about the experiences of the witnesses and the jurors, because that was so much of what I came away with thinking, wow, it really matters who is hearing the evidence and not just what the evidence is. And so that affects the writing process, right? Because then I have so many different perspectives that I'm trying to thread. And that was very intentional. I know that at least I enjoy media where there are so many different characters that you don't quite understand how it all comes together. And then when it does, hopefully seamlessly at the end, there's sort of a satisfaction or a fulfilling sense. There's a reward at the end for having put together the pieces or having it come together in that way. And so, yeah, all of that informed the way the story is laid out, what message I was trying to get across, and my experiences within the courtroom. All of that played into the structure, the format of the book.
Yes, yes. No, I said at one point early on to my wife, there's a little bit of a Robert Altman thing going on here. I can't quite tell, that is, and but then truly, as I said, like in our correspondence, setting up the time for the podcast, absolutely delivered in the last 60 pages. And it really, it's a thrill to see the strands sort of curl, fall into place and curl into place. So it was really, really very well done.
Oh, thank you so much.
And it's, I think I enjoyed the end the most, which I have to say, I think is actually kind of unusual, because usually we're so excited by the buildup that we're a little disappointed that it has to end, that we have to pick an ending, if you will, given the possibilities. But this really was, I think, the reverse for me. The ending really did pay off, and not just in 3 pages, but over an extended period of the novel. I have one last question. We've talked for a while, and I'm grateful, for the time. As right before we got on, I went through the book, and I was looking at the acknowledgments, And I know that one of the people you thanked was a professor at law school. I hope I get the name right, Dan Kahan.
Hmm.
And I'm a little familiar because he did this sort of super big article about juries. Or I think maybe he was a co-author on a big study of juries. I think I'm approximately correct. That is, I'm in the ballpark there. Can you just say a little bit about um, his work and how it influenced you, and there may even be a sort of more personal, influence that he may have had on you. I just wanted to, um, you know, I guess I'm speaking up for the law professors here by asking you to talk about one of your former teachers.
Sure. No, that works. No, so his, you know, that criminal justice course that I took, criminal law that I took with him, was, it had to have been 1 L year. And it really was the preface. It really is what pushed me in part toward criminal law. I had already that inkling, but it was that course, and it was, it wasn't structured around the rules, for attempts, or uncompleted crimes, completed crimes. It wasn't very formulaic in that sense. So in a way, it wasn't particularly helpful for the bar. It was very much, he was a visiting professor from Yale Law School, so at Harvard, and so it was very, very theoretical, very up there a little bit, high end sort of thinking as opposed to down in the weeds. But I really enjoyed that, and what the work that informed a lot of my studies and then my thought process in terms of jury picking was about how there were two different really types of jurors. I think he called them egalitarian, and then like traditional might have been the word, or it's conservative and liberal, progressive in essence, and how there are just certain caricatures or certain or archetypes to each of those types, and how that plays into what their verdicts are going to be, how that affects the verdicts. And so it really didn't come together fully for me until I was picking a jury, and I could see, and we all understood what it is that who we needed and who we didn't need, right? We understood why the defense attorney was asking to strike this person versus another. We understood why at times they would claim a Batson discrimination claim, right? They would say, oh, the prosecution is merely trying to eliminate a member of this protected class. And I know a lot of also prosecutors of color would get very offended, and they would put on the record their own race, which is fine because the record can't capture those sorts of things. So I understand, I suppose, for future appellate purposes. But obviously, people of color we can all be discriminatory, particularly racially. It can be subconscious. It can be hard to unlearn. It can be deep within us and not, on the surface. And so that's not necessarily a way to combat that. But they would say those things. They would claim a Batson claim. And everyone in the room would kind of know it's disingenuous, especially with the jury system we have in Florida, because we heard the person speak. And so we know that had nothing to do with their color of their skin. They had just, let's say, gone on a diatribe about how much they hate officers. That, is not going to be a very pro-state juror, right? Especially if your case, let's say, is mostly officers, mostly officer witnesses. And so it just became so obvious to me and to everyone in the room, the types of people we were picking, and how in a minute you can get a flavor of a person. And it could be inaccurate. It's not necessarily right. With your story, you talked about that the sort of what they picked up about the lawyers was actually inaccurate, right? Because it's all performative. And so, and jurors are sometimes very good at performing too, in that moment of trying to be as impartial as possible. And then you talk to them afterward, and it all falls apart. They were just saying what you wanted to hear. And so putting those lessons from what the professor taught me and seeing it come alive is really what it was, that gotcha moment for me, where I realized, like, this is the ball game. This 3-hour first jury picking, this is what we're talking about. They're not saying it, but we all know we're trying to figure out who this person voted for in the last election. And if we could just do that, we probably could just sit down and have a much faster jury picking. Because that's what we're trying to get. Political parties are good at that. They sort of encapsulate kind of like all the things, all the virtues that you find important to you, right? And the things that you find offensive. It's a nice sort of way of just like encapsulating a person. And so there's a reason that we sort of have like two major parties in this country, and they kind of align kind of nicely with our worldviews. those worldviews were really, really important. And that was what I had learned in the classroom, but it didn't really come into full effect and become real to me until I was actually practicing it.
Yes, yes. Well, that's a great way to end, at least for a law review podcast. Um, uh, Students out there, see, your professors do have something to teach you. We'll end there. It's been delightful. Thank you so much, Robin Peguero, and I can't wait to have you on for your next book. Thank you so much.
Absolutely. Thank you so much. I enjoyed it.